Okay, landlords, you have multiple buildings. You're doing very well in your life, but you think that you can delegate liability by hiring an independent contractor to make your premises safe. The law says that's bullshit. You as the landlord are 100% responsible for any accident that happens on the premises. Now, there are some exceptions, but before we get to the exceptions, let's talk about why. The law in the state of New York says it is a non-delegable duty to maintain the premises in safe condition, and specifically when you enter the premises and when you leave the premises. So, if you're a commercial landlord and you're out of possession, which means you're never there, and you give all the units to commercial tenants, and somebody busts their ass in the building, you as the landlord are responsible even if you hired a separate maintenance company to do the maintenance in the building. You cannot delegate, you can't give that responsibility to somebody else from a legal perspective. Now you can give it to somebody to do, but it doesn't mean that that independent contractor now, that sweeping company, the cleaning company, the snow removal company, they will not pick up the tab for the landlord. In fact, the landlord is still liable as a matter of law for any injury that occurs on that premises. The exceptions to the non-delegable duty for a landlord is if you're a residential landlord and you rent out the premises to a tenant and now you're out of possession of this premises. If you rent it out, you're not responsible. Now that tenant is responsible. Always have something in writing between you and the tenant. It's very important. But again, if you're a commercial landlord and you have it in writing that that independent contractor is responsible, it means absolutely nothing in a court of law. Landlord's still responsible. It's non-delegable. You're liable.